The topic that I'm supposed to talk about today, I think, is the history of rate regulation in the United States Supreme Court. And so I will teach this topic the way in which I teach every topic, which I go back to some medieval or ancient authority in order to put the stage so that you can understand some of the more modern developments. This is a talk which I gave actually before the Supreme Court Historical Society, which was an appropriate forum. I will not give the same talk here because I don't even know how to give the same talk once, let alone twice. But what I will try to do is to sort of cover some of the major themes associated with this operation. And in this particular case, there is a direct historical line which begins with the publication, or the non-publication, I should say, of a treatise called a Portis Maris of the Gates of the Sea, written by Matthew Hale in the 17th century towards the end, just about the time that John Locke wrote his treatise, Second Treatise of Government, which was only published about 100 years later, and then became the basis of all of the modern law on rate regulation, first in England and then in the United States. And the proposition that was so important here was that our friend Hale found a third category of cases that somehow or other stymied the standard Limitarian dilemma, which says that whenever you're engaged in the use of force, you have done something which is very bad. Whenever you've entered into a voluntary transaction with somebody else, you've done something that's very good. The explanation for that dichotomy, I think, is clear enough. If you push very hard on the force side of the issue, what happens is aggression manages to produce modest gains for the winner, catastrophic losses for the losers. As they say in the garment business, you don't make up in volume what you lose on each piece. And the same thing is true with respect to aggression. The more that happens, the worse things start to get, and you descend, as that 17th century figure Thomas Hobbes said, into the war of all against all, which we don't want to do. Consent, on the other hand, tends to work very much in the opposite direction. You produce gains to the two parties to the transaction, which leaves each of them richer than they were before. Each of them can then enter into other transactions with other parties, so that whereas force shrinks the pie, consent expands the pie, and hence the standard dichotomy between them. The explanation, however, of larger social phenomena is incomplete if the only thing you do is to focus on these two extremes. In the middle is the case which our friend Hale called those cases of businesses that are affected with the public interest. And he put these in opposition to those businesses which were governed by what he called the juris privati, that is, by the private law. And in the private law, he was a good Chicago economist, and he says essentially the way in which you do well in business and well for a society is to allow each person to sell whatever he or she owns for whatever price he or she can get from other people inside the market. And in a competitive situation, that will produce generally very fine results. But he says if there's somebody who has a license from the Crown on the one hand, or operates a business in a locale where he has no direct competitors, this industry is now affected with the public interest, and that means that the rates that have to be charged must be just, reasonable, and non-discriminatory. He did not use the word monopoly in the way in which he described the situation, but the implication was absolutely clear from the context in which he put it, and his basic particular point was that if you have a monopolist who supplies goods in a market where free entry is not possible, the prices will tend to be too high and the quantities sold will tend to be too low. And so something must be done in order to stop this. But he recognized that the monopolist is not the same thing as the predator, that is, the person who engages in aggression, because if you say with aggression, we're not going to allow it at all, there's going to be no massive resource misallocation. But if you say to the monopolist, we're going to starve you of all revenues, he goes out of business, and everybody turns out to be worse off than before. So the challenge, according to our good friend Hale, was to find a situation where the rates would be kept reasonable on the one hand and non-discriminatory on the other hand. You had to make them reasonable because they had to be high enough so as to sustain the operation of a business, which after all is an essential service if it's the only one that's around, but low enough so that they would not allow monopoly extraction of rates, and fair enough so that you could not pick favorites amongst your various customers, thereby disadvantaging some of them and giving preferences to others. He did not explain exactly how this particular thing was to be done because he was talking about this in the most general terms, And so the usual problems that you see in law always arise when you try to take a perfectly good general instinct and translate it into a series of workable and operational rules. That opportunity came in 1810 in what is one of the most important cases in English law, a case called Allnut and English, decided by Lord Ellenborough, and it had to do with the operation of customs houses in England. To set the stage, it's very clear that when somebody imports goods into a country for resale inside the country, many mercantilist policies often take place. And what happens is these goods are subject to taxes and customs duties of one sort or another. On the other hand, if somebody wants to store stuff in England for transshipment to another country, all of a sudden the market conditions change, because if you charge the same tolls on these things as you charge on stuff for domestic imports, folks might go off to a Belgian port or to a Dutch port, and you will lose all the customs. So what they did in effect was to create a series of bonded or warranted custom houses, and the basic operation was that if you were going to use the London ports for transshipment to somewhere else, you would be free of the customs duty. What happens is somebody gets one of these licenses and then promptly raises the prices that he can collect from his customers to reflect the fact that he has this local monopoly position. And if in fact you allow him to do just that, the Crown will hurt because he will be better off, but the whole purpose of the custom house, which is to make sure that goods are routed through London, will be undermined and people will start to go elsewhere. So what they said is this is a business created under license, so therefore it's affected with the public interest. And therefore what happens is you can only charge those rates which are mild and moderate. Well, they don't have to figure out exactly what those rates were because it turned out that other businesses gave you all the information that you needed. Our particular applicant in this particular case refused to pay the higher toll. What he did is he went off into the general market, and then what he did was he paid the taxes, and he sued essentially for £500, which was the differential cost that he had to pay by virtue of the fact that he could not get the customs house at a competitive rate, and that particular action was allowed. So the rate-making problem was essentially trivial in this case because it was handled not by a prospective system. We are trying to figure out how you price utility services of one sort or another. It turned out that there was an easy comparative competitive market benchmark which allowed you to figure out what the damages would turn out to be. So the principle was established, but the institutional complications associated with its operations were by no sense resolved. Now you might ask what a decision in 1810 in an English court has anything to do with American rate regulation. Normally what you would do is you'd ask me to speculate about how the influence of these ideas worked their way across the Atlantic into a very different constitutional environment, but happily there's no need whatsoever to engage in such idle speculation. The initial case in the American law on rate making comes after the Civil War. It's a case called Mun Against Illinois. It is generally regarded as a landmark case by everybody, and what it had to do was to answer the question as to whether or not the state of Illinois could in fact regulate the prices that various storehouses and warehouses for grain that were being shipped across the United States. To get to this question through the state of Illinois, in 19th century jurisprudence, they had first to decide that if you had in fact a warehouse that stood between two journeys on a train, it was not part of interstate commerce, but was in fact an exclusively local activity. And so dutifully they basically said the state had exclusive jurisdiction over this issue under the Commerce Clause. That's not the Commerce Clause that you and I know today, but it is in fact the one that was actually put into place in 1787. Then the question was, what do you do after this particular element takes place with the rates? And here everybody understood that there was a risk of monopoly associated with these particular operations. And the solution that was thought to be appropriate by Morrison Waite, who was the Chief Justice at the time, was to say the state legislature can set the rates directly or by administrative bodies at whatever level it wants to do. And in fact, if there is some objection to it, the remedy lies not in the courts, but at the polls, was his famous expression. Now, it turns out, he said, the people have the remedy, but the legislation in question was a populist movement, part of the Granger movement of the time, and I could assure you quite definitively that the people would very definitely vote to keep the rates in place if this thing will put up the popular election. So this is a classic illustration in which the risk of confiscation through popular democracy was large enough, and it turned out there was nothing whatsoever in the Mun decision which was intended to counter that particular kind of danger. And what then happens thereafter is essentially a repudiation of Mun on one of its 2 points. The point that is continued to be accepted is that rate regulation is permissible for the reasons that have been discussed earlier by Matthew Hale, but the point that was rejected was that the only remedy lies in the polls. And instead what happens is people start thinking very seriously about creating judicial remedies. Remember, this is a period at which the Interstate Commerce Commission starts to come into effect in 1886, and it's the first time in which we have really grand monopolies. We have the railroads, which have some monopoly powers. We start to develop public utilities, so that you then have to really ask the question as to, when you don't have competitive solutions for these very complicated natural monopolies, territorial monopolies, network industries, just what do you do to make sure that the rates are not so high as to be extortionate and not so low as to be confiscatory? When the problem came to its head procedurally in 1890 in a set of cases known as the Minnesota rate cases, which came out of a very populous farmer state, Minnesota, in which a very distinguished judge, William Mitchell, for whom a law school is now named, decided that Mun meant that when the legislature decided to delegate this particular authority to an administrative body, whatever rates they set was conclusive, and you were not entitled to a judicial hearing to challenge the outcome. When it got to the United States Supreme Court, they did exactly the opposite thing, and they said, look, at this particular point, the risk of low rates turns out to be potentially confiscatory. We do have, from the 14th Amendment, a due process clause, which essentially says that nobody should be deprived of life, liberty, or property without due process of law. It does not take a great imagination under these circumstances to realize that the ability to get a hearing in which you can challenge these rates and then get judicial review, at which point they can be overturned, is not beyond the ken of the situation. And so what they did, in effect, is they introduced, at this point, the possibility of a direct system of judicial review over the rate-making process. In 1908, we have another one of these great procedural cases, also coming out of the state of Minnesota, a case called Ex parte Young, which many of you will start to think of as an 11th Amendment case having to do with constitutional law. But what you have to remember about this particular case is that it is indeed a constitutional law case. It does indeed concern the 11th Amendment, but it is also a rate regulation case, and that explains much of what is going on there. The difference between the Minnesota rate cases and Ex parte Young is easy to state. The Minnesota rate cases delegated the rate-making responsibility to a commission, whereas in Ex parte Young, the state itself simply set the rates by way of legislation, so you did not have this second level by which you could challenge the particular determination. At that point, Justice Peckham, the guy who wrote Lochner against New York, got it right when he said, you can't run this system through legislation any more than you could run it through administration. So what he did is he created all sorts of fancy artifacts under the 11th Amendment to say that you could sue the Attorney General in order to enjoin the rates, and in so doing you're not enjoining the state in ways that would be prescribed by the 11th Amendment. I don't like that particular rationale. My view about it is that once he decided that the rates set by the legislature were indeed confiscatory, which he had done, he ought not to worry about the hearing question at all. He should simply say, sorry guys, the due process clause applies to you every bit as much as it does to the administrative agencies. You better start over again and make sure that you get the rates right before you go on. So this is a classic case in which the more timid approach creates all sorts of complexities for the 11th Amendment and does nothing to help the cause of sensible rate making. Well, at this particular point, we then have another problem that we have to start to face, which is exactly how do we determine these rates anyhow, if in fact we now decide that there's a constitutional standard which allows us to pass those rates which are reasonable in some sense and to deny those rates which turn out to be confiscatory. So side by side with the procedural issues that I've just been talking about, there starts to develop in the early 1890s, going all the way through the end of the Second World War, and maybe a little bit further, this elaborate substantive body of rate making, which starts to try to put flesh into what's going on in this particular area. Now, in this particular case, what is so unusual about the overall situation is as follows. I think it's fair to say that the actual formal mechanics and economics of rate making were not fully known at the time that these decisions came down, to put it mild. The most famous treatise on this particular subject was Alfred Marshall, writing about the principles of monopoly or of economics in 1890, and he was the first person who actually systematically could explain why it was that there were distortions in economic welfare or social welfare that were created by the imposition of monopoly pricing. It seems pretty clear that none of the formal demonstrations had worked itself into the earlier cases, especially those that had been decided prior to that time. And as usual, the ability to infuse legal wisdom with economic understanding is not the work of a day or a year. It is the work, at best, of a generation. So what's so amazing about this overall situation is the guys who do not have the benefit of a very strong economic theory as to why it is confiscatory rates are dangerous and why it is monopolistic rates are dangerous, did much better in dealing with that subject than the modern judges tend to do. And I think the explanation lies in not the knowledge of economics, but in one's attitude towards American constitutional law. I have said on many occasions about many topics, and I will repeat it once again, the single greatest curse with respect to the doctrinal development of American constitutional law is, when the government is engaged in regulation, the willing adoption of some kind of a rational basis test. What the rational basis test says, in effect, make as many mistakes as you want, but so long as you can show that somebody benefits by the rules that are now in place, you have done all that is needed in order to make sure that the statute is constitutional. We as learned legislatures do not pass upon the wisdom of these statutes. We just want to make sure that they have some minimum connection with social reality. And if you think about it, although the term was not current at the time, that is very much the kind of position that was actually adopted by Morrison Waite, when in fact he said in Mun v. Illinois, all the issues go to the legislature and to the polls, none of the issues start to come here. What the rational basis test says is it really pays to be stupid. And so therefore, if you take off your thinking cap, don't look at the wisdom of what's going on, turn the blind eye to the politics of the situation, ignore all the public choice elements, figure out that there's nothing you could do about matters of resource allocation, you will be sure to get it wrong. And if you're sure to get it wrong, it means you're sure to let these things essentially pass. Once it turns out that legislatures know that they will get a free ride through the courts, their behavior will become more ridden with interest group preferences than would otherwise be the case. So what you do is you get the modern degenerative social equilibrium in which weak oversight by the courts leads to irresponsible behavior by the legislature, which leads to a progressive decline in the level of growth and vitality inside this country. Make no mistake about it, the level of economic performance in the United States by any of the standard measures between, say, about 1890 and 1937 far exceeded that which has happened under the modern rules, and to the extent that there were catastrophes that took place, for example, during the Depression period, many of them can be treated to the fact that the one thing you could never do through the course was to control the way in which the money supply worked or to deal with the free trade issues. So between the massive deflation of the early 1930s and the Smoot-Hawley tariffs, which killed off international trade, it turned out that we managed to have a series of very powerful disasters that took place independent of these rate-making issues. But on the rate-making side, although the terminology was not used, everybody realized that given the fact that there were two risks, one, too much government action, and the other, too little government action, the courts basically decided themselves that what they had to do is to see if they could find a way to find the golden mean. And this then leads to the following attitude which is taken towards judicial review, which should last to this day, but generally does. On some questions, you can find that the balance of convenience, pro or con, a given system of rate regulation is really very hard to determine. There is no dominant solution that the most professional economists could think of, the wisest lawyers could advocate on the issue of how it is that you take this unruly monopoly and turn them into a tame and proper regulated industry. And if in fact there are pros and cons between two kinds of positions, neither of which has clear dominance over the other, it is appropriate under the circumstances to allow the legislature to choose that particular form which it thinks has the fewest inconsistencies, so long as it essentially applies the same formula consistently all the way through. And there are, in dealing with rate issues, questions of exactly that form, for which this approach is appropriate, which are now widely ignored in the Supreme Court. On the other hand, whenever you deal with a system of complex rate regulation, there is always going to be legislative initiatives which count as low-hanging fruit. And when you come up with something which has that kind of a characteristic, and you can see theoretically that there is a dominant solution, anytime you see a departure from that particular element, what you do is you strike it down unless and until you are persuaded that the administrative costs of intervention are so great that you're better off leaving this kind of problem alone. And so when we look at these rate issues, you can see both of these things going on at the same time. And the first of the cases that I'm going to talk about here is a case called Smith v. Ames, decided I think it was in 1899 by Justice Harlan. And the kind of rates that were involved in this case were in fact of the dead meat variety once you understood what was going on. It was a case in which the state of Nebraska, represented in the Supreme Court that time by William Jennings Bryan, who had been their 1896 candidate, goes in there and they said, we've managed to impose, I think it was a 30%, but the number really doesn't matter, a very substantial across-the-board cut on the rates that every railroad in the state can charge to every customer, no questions asked, no individualized hearing given. And some of us think deeply and we ask ourselves, how many businesses manage to create a system in which they generate consistent 30% profits on an existing set of rate structures? The answer to that question is not very many indeed. You do a few kinds of simple calculations, and it turns out that in many cases, you'll turn out that you won't even be able with the rate cuts to cover the variable cost of running things on the line, which then leads you to the very clear conclusion that one of the reasons why you must have rate regulation protection is, in fact, in order to run this business, you have to invest heavy amounts of capital first and then recover it later, so that the nasty legislature can decide, in effect, to give you some amount of money above your variable cost so as to keep you in business and still confiscate a large amount of the fixed investment. Generally speaking, you could pull that stunt once, maybe twice, but not 3 times. So unless you give some kind of systematic protection against the loss of front-end invested capital, you will basically send the entire public utility business, the entire railroad business into bankruptcy. This is a non-trivial problem because legislatures are always looking to possibilities for confiscation in order to basically balance their current budgets. One of the rules that we understand about politics is the way in which you justify current misdeeds is to engage in past misdeeds with respect to things already done. So what he did is he struck this thing down. Now what he had to do was to develop a general principle, and the principle turns out to be more complicated in this particular case than the actual result with respect to the rates. He said, look, when you're dealing with this stuff, companies make lots of investments, and if you're looking at a competitive market, when you start to invest in various kinds of resources and the investments are foolish and unwise, the risk of their destruction necessarily falls on the owner of the project who puts it in there. And that's an incredible spur in order to make sure that you try to make those investments that are prudent, that are useful and valuable in the business in question. So what he says is, I'm going to apply exactly the same kind of general rule in this case, and if you as a public utility manage to dissipate your wealth with a series of utterly untoward investments, what I'm going to do is deny that as inclusion in the rate base. Now, once you do that, you have to figure out what other adjustments you make. And if you start thinking about a competitive industry, what you quickly conclude is sometimes these investments are very risky and they won't turn out very well. And the way in which people manage to get compensation for the dry holes is a higher rate of return on those wells which actually turn in. So that the necessary coupling that you get under these circumstances is that if you give yourself the lower or the smaller rate base, what you have to do is to compensate that with a higher rate of return. Well, how much higher rate of return then becomes something, and it's not an easy question, but here again is the kind of instinct we have. This public utility is to some extent sheltered because it has no direct competitor. So while it faces one form of risk, namely getting the right kind of investment, it tends not to face a second kind of risk, which is some new guy is going to come in on the block and blow them out of the water with a superior technology they could offer for a lower price. So what you do is you then figure out what the rate base is, figure out what the normal competitive rate of return is, knock it down a couple of points, so as to reflect the fact that there is less risk in this kind of business, and you come up with 18% turns out to be 14% or something of the sort. Is the system workable? The answer is yes. Is it perfect? No, it can't be perfect, because if you don't have a market making these determinations, any administrative determination is going to be bad. But at least what you do is you have a clear understanding that these two things are paired. If in fact you give the narrower base, what you must under the circumstances do is offset it with an appropriate risk-adjusted higher return. And these guys managed to understand this perfectly well. But then it turns out we have great reformers of the progressive period, one of whom is Louis Brandeis and another of whom is William O. Douglas. And they do not like this system of rate-making base because they think it's just too complicated to figure out what goes in the base and what all these returns ought to be. So they say, we have a better idea. Well, at least it's a different idea, but it may be better. They say, we're going to give you a return on everything that you put into the business, and we're not going to chop out those things which turn out to be unwise, because now the rate-based calculation is going to be much easier than it will be under Smith v. Ames, which is an indubitable advantage. And they say, and I think they're right about this too, at this point we don't have to look at every particular expenditure you made to see whether it's wasteful or not wasteful, going through the books like they did. All you have to do is to look at the bottom line, and if that in effect gives you a rate of return that's sufficient to sustain and maintain the business, you're going to be just fine. That number they would add will be lower than it should be under Smith v. Ames, because it turns out that you're eliminated from one of the two risks associated with this business, namely the rate-make investment. So the correct view on this particular question is to say, if in fact you get consistency with respect to one or another of these schemes, by and large, it ought in general to escape constitutional scrutiny, because there is no dominant solution on the problem in question. And what happens is they sort of do this, but they don't get it quite right, because in the famous case of Duquesne Power, or Duquesne Light, excuse me, against Barash, and this was the citizen's advocate in Pennsylvania, you had a very novel situation in which Pennsylvania first authorized the construction of nuclear plants and then forbade their application. And the question is whether or not that extraordinary expense, which had been done in for them after it had been authorized, should be recovered by them, either through additional rates of one kind or another, either in a lump sum or over time. And what Rehnquist said is, so long as you meet the bottom line test of hope, I don't care. He was clearly wrong in the sense that, generally speaking, when you get extraordinary expenditures, the appropriate rule is to make the immediate and correct adjustment with them. But his attitude was, so long as you're within the zone of reasonable rates, the fact that there's this lump sum transfer is going to be perfectly okay. Interestingly enough, the Pennsylvania legislature the year after actually reversed the decision because they had a better sense of accounting than the worthy late Chief Justice on this particular point. But at least you understand that they're working in the right universe. Now, where do you get into the wrong universe? Well, if you take the cases dealing with the regulation that were associated with the TELRIC program, total element long-run incremental cost for those of you who care about it, or total system long-run incremental cost, when you were dealing with the telephone cases, this is where everybody goes off the rails. Because what you do is you now have to make front-end investments of a very high rate in various kinds of telecommunications facilities. And even though you quote-unquote call this a competitive market, you have to allow people to recover these fixed costs. And what the regulators did under these circumstances was they used the narrow rate base by telling you that as the thing depreciated, you had to depreciate your rate base. They would not give you cost recovery on original cost. And then they decided to give you a very low rate of return with respect to this investment. So that basically flunks the smell test. Why does it do so? Because you have inconsistent methodologies. You have the narrow base and the low rate of return, and that is in fact in forbidden territory. So the thing should have been struck down, but since it's a modern Supreme Court, the answer is no, it's not going to be struck down. This did not come up, I might add, as a constitutional case, but this is what in fact happened. They gave them Chevron deference as an administrative area, and Chevron deference is to administrative regulation what rational basis is to constitutional law. If you apply it systematically, you're sure to get everything wrong. And once you lose under the rational basis test, nobody except a hardy fool will want to go back as a constitutional matter and lose again under the rational basis test. So you start to see how it is that systematic ignorance can make an enormous difference, and there were billions upon billions of dollars that were wasted and dissipated by the entire implementation of the 1996 Telecommunications Act. So now, can we find other instances of the way in which the system starts to work if, in fact, we are working within the traditional Smith v. Ames framework? That is, cases which are clear enough that we ought to be able to strike these things down without having to gnash our teeth. So that, in effect, given the fact that there are clear dominant solutions, what we do is we ratchet up the review from sort of systematic rational basis or intermediate scrutiny, whatever you wish to call it, to something which is much stricter in its application. And in fact, you can find exactly these kinds of things. And let me give you 3 illustrations that come from the period between about 1890 and about 1930, which illustrate the point. The first one has to do with cross-subsidies that take place between 2 services, both of which are subject to regulation. So if you go back and you start to look at the situation in Hope Natural Gas, what Justice Douglas said is, the only thing I care about here is the bottom line, and I don't worry about errors that cancel out, because the utility, in effect, will get the correct rate of return as the pluses offset the minuses. It turns out that this is a fatal mistake in terms of the general intellectual development, not because the constraint that he talks about is irrelevant, but it turns out to be underpowered relative to the issue at question. So go back to what we said about competitive markets and ask yourself about the extent to which a competitive market will tolerate a system of cross-subsidies between 2 customers of the same firm. And the answer to that question is perfectly clear. The competitive firm can get the winners without having to take on the losers. If, in fact, what you try to do is engage in the cross-subsidy, those guys who are subsidized will come flocking to you. Those guys who are forced to pay the subsidy will desert you. You will end up all with subsidized people and no subsidizing people. And if you keep the rate structure it is, you go bankrupt. So in regulation, if you're trying to figure out how the world ought to work, you ought to have exactly the same attitude with respect to cross-subsidies. To the extent that these things can be identified as part of the rate base, what you do is you constantly knock them out lest you create this confusion. So let me just give you 2 cases. One of them involves the Lakeshore Railroad, and what they did is they wanted to give subsidized passes to certain preferred classes of former employees or customers and to force the cost off on everybody else. And the basic attitude that the Supreme Court took, I believe it was Peckham, but doesn't really matter, is can't engage in this kind of behavior because no competitive firm would ever be able to sustain those particular kinds of things. This does not require that you go through various items on the expense sheet one way or another. In fact, all that it requires is that you read the reports in the legislation or in the administrative ruling which says, we are now creating a cross-subsidy by giving these people a bonus rate for some bogus reason, and you can strike it down without having to do any rate-making determinations at all in the situation. So that's the first of these things. The second illustration is more important because it involves larger sums, and it has to do with a case involving the Norfolk and Western Railroad. And what they do is they contrive a system of subsidies, and I can never remember whether it's the passenger line subsidizing the freight or the freight subsidizing the passenger line, but it really doesn't matter. You know that whichever way the subsidy goes, it's going to be wrong, and to the extent that it turns out that this is an explicit program on the transfer payment, you have to strike it down. And Justice Hughes, the man who gave us Jones and Laughlin Steel on the Commerce Clause, in fact, did strike this thing down because in his earlier incarnation in 1915, he was a darn good rate lawyer, and he understood exactly what the dangers are. Note that if you took the Hope Natural Gas test, this thing would all fail. The difficulty with respect to the Hope Natural Gas test on this thing is by only looking at the regulated firm and not at the distortions in its customer markets, you're going to make serious allocative risk. Who was the man who understood this best after 1944? Why, it was Justice Douglas again. Because in 1953, this precise issue came up on the issue as to whether or not when you had fruit that was being taken from Texas and California simultaneously, could you require one state to subsidize the fruit of the other by giving differential rates? And Justice Black, who was a much more consistent Southern populist than Justice Douglas, who was, shall we say, a mavericky but highly intelligent man, he's willing to sustain it on the grounds that, oh, what are we looking at is all administrative determination, all too complicated for me to understand. And Douglas said, no, you're just creating massive destruction in the misbalance of the competition between these two end markets. You don't have to essentially have a great set of insights in order to do this, because a facial challenge will get it through. Well, then what does this leave as something which is much more difficult to determine? And what you discover in all of these cases, there is always the question of joint cost. And that means you have joint cost in running the services for the special employees and the general customers in the Lakeshore case. You have the same thing with respect to the rails when you have freight running over it and passenger cases, and you have it when you're serving both Texas and California. And the correct rule there is, so long as you know that the segregated costs for running each of the two services separately are covered by that services, you got to give the guys in the center a little bit of discretion in how they allocate those costs. So maybe the perfect measure is not revenues generated from each of these two services or miles driven or whatever it is, but it's close enough for government work, quite literally, this is not meant as a joke, that so long as you know that they're trying to do it in a correct fashion, then you don't come in there and start with calibers saying, no, it really shouldn't be 40-60, it should be 42-58. There's nothing whatsoever that you could gain from that inquiry. So again, the basic principle holds. More deference in those cases where there's a genuine difficulty of figuring out the dominant solution. No deference whatsoever when on the face of the record there is a distortion from what would be ideal competitive conditions. Now, the second of these cases involves a situation where the cross-subsidy takes place between one regulated industry and another industry which is not regulated, both of which have some common costs. And Justice Holmes was actually a pretty good rate regulation lawyer, said you can't force the regulated industry to take a low rate of return on the grounds that you can make it up from the non-regulated industry for all the same kinds of reasons that we were talking about before. The distortions will just become too great, and it will give you a powerful incentive to divide the businesses into half so as to raise the rate on the regulated side, which may destroy some efficiencies that are associated by having them under common management, or at the very least cost you the very substantial sums that it is needed to sell off one business of another, which will be even harder if they have some joint cost allocations associated with it. Same principle as before, another case of low-hanging fruit, basically don't tolerate it. And the third danger that you can't tolerate is one that was picked up in a case called New York Telephone in 1926, I think it was. And here the issue was, I'll tell you what, we're going to basically tax you too much today, not allow you to recover your full depreciated costs and so forth, but you can make it up tomorrow. And so what they're going to do is to essentially get rid of the notion that each period has to be essentially self-sufficient under a rate base, because what you lose today you could gain tomorrow, and tomorrow, and tomorrow. Because what happens is the moment you start to allow these kinds of deferments in one period, you can't confine it, you'll do it in the second. And even if in the second period you authorize the higher rates, there's nothing which says that you could charge an authorized rate if the market, even under monopoly systems, won't bear it. And there's no reason why you want to distort the market between current and future customers and so forth. So that what you must say in all of these cases is each period under the rate system has to be able to be self-sufficient. It's again something that you can do superficially by the overall examination of how the things are put together. And if you do that, you will note that the Telerik or Testwick cases that I just talked about, where you postpone the rate regulation to another day, have to be per se wrong, because they essentially are all involving in shifting costs back and forth, not only between customer classes, which they also do, urban and rural users, residential and non-residential users, but also between times. Now, the question you then have to ask, and I'll just summarize right here, is just what does all of this nightmarish situation cost? And the answer is not millions of dollars. It's probably billions and tens of billions of dollars. Because right now what happens is whenever you start dealing with any of these kind of complicated rate hearings that take place with electrical generation, or take place even occasionally with respect to the rails, or with telecommunications in particular, or maybe even with the internet, if you have the rule that cross-subsidies are okay, inside a regulatory framework, you have a rule for the massive dissipation of wealth. So go back to what the central proposition was, and you'll see why this is wrong. The theory of rate regulation of those businesses that are affected with the public interest is to make them behave to the extent that it is humanly possible as though they were in a competitive environment. If you know, in effect, that no competitive environment will tolerate cross-subsidies for the reasons stated, then you know that the effort to introduce cross-subsidies under a rate regulation scheme should be per se illegal, which means that a large amount of business which now takes place in state and federal administrative agency is in fact marked with an original sin which only their total abolition will eradicate. Thank you. Well, that's the way I teach con law. Oh, I dare not say. Are there any questions, I hope? Oh, come on, this can't be. You're on camera, guys. You have to hold up the honor of the University of Chicago. Yes, thank God.
Okay, so given that you don't think the current structure works whatsoever efficiently, what's the alternative?
Go back to the earlier rule. I mean, look, what happens is, the point about this is, when I defended the kinds of rules that were used in this particular period, I don't mean to say that every one of them was perfect. There were a few mistakes here and there. But essentially what they did is they had a relatively stable system of rate regulation, which facilitated the enormous growth of regulated industries because they could enter into their businesses without fear of confiscation, and in effect managed to create general consumer welfare because people knew that they could not be extorted by a single supplier of goods under any circumstance. So if in fact you have a set of rules that works, the way in which you think about the challenge is follows. Look at any one of the rules that we talked about, either in the iffy, we're not quite sure which way it goes class, or in the clear, oh my God, they ought not to be allowed to do this class. Explain why it's wrong, and if it's wrong, then we will start to change it. But the key point to understand about this on levels of judicial scrutiny is one of the things that's so wretchedly wrong with the current Supreme Court jurisprudence is what it does is it makes these judgments categorically, if you go back to something like the Caroline Products case. It says, oh, you're just dealing with mere economic regulation, so you get bare bones rational basis security. You're dealing with a First Amendment issue, including many First Amendment issues that arise out of the regulation of the internet and telecommunications. Now you get strict scrutiny. I'm giving a slightly different view. This is not content-based description, so we don't have to worry about the First Amendment overlay on that point. But essentially, the correct test is, if in fact your best understanding of economic theory yields no dominant solution, then it's an error trade-off, and to that extent, there ought to be some degree of discretion to an administrative agency, so long as it adopts a consistent methodology from beginning to end. So the constraint is consistency in the model. But if in fact you look at this thing, and you know that it's just asking for trouble, what you then do is to say, no, you can't do this at all. You've got to get this thing clean. Once you get it clean, the political benefits are enormous because people will no longer spend money to lobby for particular results that they cannot achieve, which means that the endless inundations that you start to get into various regulatory agencies with special pleas as to why I'm wonderful and everybody else is wretched start to disappear. The cost of the situation starts to go down. You can now spend more money on getting accurate resolution of the kinds of difficult questions that remain under the system, and the overall level of the system starts to improve. Now, if I made a mistake in any one of the categories, please tell me, and we'll try to figure out what's going on. But I think what we really can do is start with the Hale instinct about what it is to be affected with the public interest, and then take it. Let me, since I don't have a huge number of questions, I'll take another one, but let me give you another riff. Oh, do you have a question?
Yes.
Let's have the question, and then remind me to talk about NEBU.
About what?
NEBU.
Okay. So my question, so when I read Duquesne, I believed that it was actually kind of hard to figure out what should go in the rate base, and I believed that the used and useful language in the statutes actually kind of mattered, but I could be totally wrong.
No, you're not totally wrong.
So, I mean, I do worry about the gilded toilet seat in if that can go into the rate base. Sure,
You're right.
That can go into the base, and even more realistically, you're going to get overbuilding, which is extremely wasteful, especially when you're dealing with things like nuclear power plants, because hey, maybe there's only a 10% chance that demand's going to go up enough that we need this, but let's build it because we're always going to be able to get our guaranteed return on it. And oops, it turns out there's all sorts of reasons. There's the economy's crash, et cetera. So
those are issues which fall into the gray area. My view about the nuclear power plants is the legislature is entitled to make the right or wrong decision once, but they're not entitled to make it twice. Which means if they decide that they want to put these things up and to tolerate them and to encourage it, They do so, somebody acts in reliance on that, you almost treat it as though it's a contract. The case authority for that is Wisconsin Railroad against Powers, a 1903 Holmes decision, which can kind of bind you to those sort of representations, although Holmes came out the opposite way, wrongly, in my view, on that case. So you could do that. With respect to the gilded toilets and so forth, I mean, my view is if, in fact, they're having a risk-adjusted rate of return at such and such a level, and they put that in the rate base, they're hurting themselves as long as helping everybody else, and that the real issue in those cases is probably not rate-based protection, because the rate bases are done under general bounds, but the question as to whether or not shareholders of this particular firm can say, notwithstanding the general deference that we give you under the business judgment rule, the gilded toilet seat in the CEO's office does not, in effect, pass the sniff test, and we can shut it down that way. And notice, by the way, that the combination of the fair value rule and the business judgment rule is an exact parallel to the kinds of arguments that I've made here. In fact, when you're talking about business judgment, it's always the case we don't know whether this is better than that because there's a trade-off to be made. And if, in fact, you punish the people for making the wrong trade-off, you have to award them inordinately for making the right trade-off. Otherwise, the business goes out. But on the other hand, when you're dealing with self-dealing, when I sell you an asset for the firm that's worth $1 million for $100,000 because we happen to be married, that $900,000 loss is a perfectly self-evident situation. That's low-hanging fruit, so we raise the level of scrutiny to a higher level than would otherwise have been. So this model of dual levels of scrutiny, which I'm talking about, right, in connection with rate regulation, carries over with respect to the corporate stuff. And it's absolutely critical that you keep the separation between these two things, because if you abandon either of the two poles, you'll get one kind of massive abuse or the other, which is why it is that I think if you even look at the recent decisions in Delaware law on this thing, the importance of this particular distinction, if anything, has been strengthened in recent years rather than weakened. And I think it's also important to note that generally speaking, we don't want to have too many things that fall into a tertium quid category. That is, some middle ground where there's some other standard that we use where we don't know whether it's fish or fowl because we can't play the game. The way you handle that is there is another doctrine in addition to loyalty and business judgment, dealing with sort of negligence in the operation of a business. That is certainly possible for one to use, but in my own view, and I think, I'm not a full-time corporate guy, the number of negligence cases that you come up with is relatively slight compared to the number of cases that involve the choice between business judgment and so forth. And the basic argument is it's not really a negligence standard. It's much closer to a recklessness standard in which you're not trying to gain something, but you're so infernally stupid a way in which you particularly approach the problem. You listened to advice from everybody and decided to ignore it, and you went headlong over a cliff like many corporations are willing to do. That might generate something. And what usually happens in those cases is people take the recklessness, try to flip it back into the business judgment rule by treating it as a strong presumption that if you're this stupid, you have to be corrupt. And you don't quite get it right that way, because if they can show that there was no quid pro quo and no gain, they win notwithstanding the presumption, and you therefore might want to create it. That's in the, well, do we not want to do it grounds. Tough question to answer. But I think with respect to the Duquesne case, what I said is correct. And this, of course, is enormously important because, say, take a large company like Duke Energy. 20 years ago, the government's saying, build us more coal plants. We need cheap coal. Coal, 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 coal. Now we come back and we say, global warming, shut those coal plants down. Bad, 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 bad. And you're playing the switcheroo. And so the issue, which is a hard one, is you take the undepreciated value of that particular business and say, if you want to shut them down after giving them the authorization, is it just another version of Duquesne power where you have to pay them some compensation for the stuff that's lost? The moment you require the compensation, what they will do is they won't shut them down. They will kind of require them to be retrofitted and modified in prescriptive ways so that the regulators are under discipline as well as the regulator. The fundamental problem that you have to worry about is that when you're dealing with regulated industries, there are two sets of scoundrels that have to be dealt with. One of them are the firms, and the other is the government, right? And you never know who's the biggest scoundrel in these cases. Now, if the courts, in effect, say, God, we don't even want to try to figure that out, now we've got three scoundrels in the game. And what will happen is, on the private side, there'll be much more precarious nature because the combination of the discretionary judgment rule with respect to the Federal Tort Claims Act, the general business judgment rule, all kind of sort of deferential attitudes under Chevron mean that if the state misbehaves, it's almost impossible for private parties to sue them for breach of contract, breach of this, breach of that. And that, in my view, has to change if we're going to try to get ourselves a coherent regulatory type structure. So I think all of these issues are extremely important, and I don't want to say in this middle case you always get a right answer. But what I want to say is if you don't distinguish between easy cases and hard cases, it's amazing the number of easy, wrong cases that start to be legitimated. And a passive Supreme Court is, to my mind, in serious dereliction of what I regard as a very serious function. And it's not one that I think, oh, gee, I really think that they can do it. It's one that they actually did before they knew how to do it. Now we know how to do it and we refuse to do it. This does not strike me as being paradigm. So again, I sort of put the question out there. Look at all these variations, find any other one that you have, and let's see if there's a serious mistake in these earlier doctrinal developments. And I think amazingly enough, the answer is no, on both the procedural and on the substantive side. And that's an incredible achievement, right? So since it's a great achievement, we trash it, right? That's the great American tradition. Yes, sir?
Hey, I wanted to hear more about why cross-subsidization is bad.
We hear more about what?
Cross-subsidization. So like the good version of cross-subsidization is where we say like, we're okay with having lots of people not living in our biggest cities, and telephones are really important for being part of society. So, you know, having the telephone, like we might not think that they would adopt telephones very quickly because of collective action problems, because of excess momentum and communications, all those kind of things.
You want me to give my answer? Yada, yada, yada. I think every one of those arguments is more dangerous than the next. And let me start to say exactly what. When you say, in effect, we really want people to live out inside the country somewhere, I want to know who the we turns out to be. And in many cases, it turns out to be people in the cities who would rather have no new neighbors in there. I can't even figure it out. Or sometimes it's the standard farm lobby, which is disproportionately represented in the Senate, and the same preference for rural telephones is the same preference that gets you all the agricultural subsidies. And so the moment I start thinking about where this comes from, I think of somebody like Chuck Grassley, and I think he may be a Republican, so what? You can't think of anybody more useless on these issues. You want to do this, you might as well subsidize ethanol, whatever else it is that you want to do. Second thing is the moment you give the guys the subsidy, it's amazing how the subsidy will start to grow. So what we have to do is lay the finest lines through miles of cornfield so that one farmer, who may move in 2 years anyhow, is going to get service, the fixed cost of which is a couple of $1 million, and the variable cost which he has to pay will be subsidized at $50 a month. Well, suppose you said, look, this is a different world. What we want you to do is get a very good cell phone. And then what we'll do is we'll give licenses, and anyone who wants to basically give a bump-up station can do that. And you know what? The service will cost 3 times as much and probably be only 80% as good as the other subsidy type thing. But you'll save $10 million per phone, or $5 million, or $2 million, or whatever it is. So one of the dangers of giving the subsidy out of this cross-subsidization system is it takes the responsibility away from the government because it's no longer a direct item, which a deliberative democracy can do so, and then the whole thing starts to get inflated beyond all services because people will start to say, I'm entitled to equal service with everybody else, forget about the fact that they're on equal cost. So I regard those arguments as so dangerous, so utterly, shall we say, insidious with respect to the overall fabric of government that I have this solution. What we should do is go to the fair citizens of Iowa and ask them whether or not they are willing to put in the Iowa state budget an item for $100 million in order to subsidize 100 farmers. And I guarantee you Mr. Grassley will not be able to get any traction in the state of Iowa, although he might be able to get a lot of traction by hiding it in a rate regulation order, running it through Washington, where a mere $100 million subsidy is so small that nobody has the slightest interest in the way in which it starts to take place. So when I mean no, I don't mean few, I mean no. My own view is I regard all the subsidies done through legislation as every bit as insidious as those done through indirect regulation in terms of their consequences. I'm going to lose that battle constitutionally. I might be able to win the one on regulation. But the big difference is the more explicit you make it, the more I can now charm the rest of the world by announcing that I too believe in deliberative democracy, which I do, because now you put all these things on the table so that by making the thing overt, you reduce the probability of its passage and the size in the event of its passage. And in a world of imperfect alternatives with flawed judicial philosophies, I'll take whatever little savvy I can get by whatever methods can be done. But I do not want those arguments. I mean, the kind of arguments, they literally give me hives because they because they pass the rational basis test. You could find one group which has benefited, the courts will not look at it, notwithstanding the fact that any piece of general theory will tell you that the net social losses from these private gains are so great. Now, understand, this is not radical individualism, right? Not a type of privilege. This is a straight social welfare function that's going on here. One of the terrible mistakes of modern American jurisprudence is anytime somebody talks about laissez-faire or any of its variations, you always think of it as possessive individualism, egotism. It's not that. This is the only effort, the only theory which tries to figure out what a systematic social welfare function looks like and then make sure that particular actions are taken with respect to it. So it's exactly the opposite. The real egomaniacs turn out to be those people who are demanding the subsidies. Well, I have time for one more question where I could talk about NEBU. Let me talk about NEBU. I won't let you go with it. One of the interesting variations with respect to the problem of affected with the public interest is the decline of the standard as a constitutional matter. And what happens is there's a case which comes down in 1934 called Mun Against New York, in which the issue is whether or not it is permissible for the state of New York to make it a criminal offense to sell milk at a price below a certain set statutory standard. And the reason that this was imposed, of course, is instead of talking about a competitive equilibrium, we now talk about ruinous competition. Instead of talking about how it's important that competition weed out inefficient producers, well, we talk about how there's always a social need, just like with the farmers out there, to make sure that inefficient producers stay in the market as long as possible. And so what you do is you now set minimum prices. And in Nebu's case, the guy sold the 2 containers of milk at the stated price, but threw in a loaf of bread, which meant that therefore, since some of the consideration had to be allocated to the bread, it turned out that he was selling the milk at below price. And for this, the great New Deal synthesis was send this man off to jail or put him to a fine. Now, what's going on? If you go back to the earlier account of regulation that I've talked about, essentially the entire effort from top to bottom was to figure out how much of the competitive solution we could salvage with respect to the organization, right, of a regulated industry. Now, when you start dealing with NEBU, you get the following piece of New Deal madness. The villain of the piece is now the competitive industry that works well. And the sole question that we have to ask is how could we make it into a monopolistic or cartel industry? That is, the New Deal did many useful things, I think, in terms of trying to figure out how it is that you could get people back to work with the CCC or whatever it is, some of the cash payments. But its major enduring contribution was the relentless creation of socially destructive cartels, which long outlasted it. The agricultural cartels are still in place today, even though they were introduced in the 1930s. And what NEBU said is, oh, we don't understand anything about this business, so you could take a doctrine like the affected with the public interest, show that there's some marginal cases where you don't know whether the firm is monopolist, and then turn around and say, oh, this stuff is just not worth asking about. And what we're going to do essentially is allow you to set minimum prices to facilitate cartels when the original purpose of the doctrine was to control against monopoly abuses. Now, once you get there, there's no trade-off, because in this particular universe, there's no confiscation risk with respect to the cartel members who are getting a premium. So you don't have to go through rate-making procedures of the same sort, and you can just put these things in place whenever and however you want. And what the Supreme Court should have done is to say, this is a perfectly clean case of massive abuse. You cannot use the government power to reduce social welfare by creating cartels for the privileged few. And so therefore we will keep to the old doctrine and remember what Matthew Hale said, which is in voluntary exchanges, the ordinary rule is jus privati, meaning everybody gets to charge what he wants to whomever he wants. He got it right. Generations of Supreme Court justices have gotten it wrong. And when you want to look at the current economic malaise, go back to those New Deal cases and to its modern University of Chicago avatar who manages to embrace in Washington every one of the wrong prejudices with respect to economic regulation, and you will discover the sorrow tragedy of our own age. Thank you.